Today's lecture would be devoted to one of the national and international legal issue involving criminal jurisprudence and in particularly the provision of offenders as it is falling under the reformative theory of punishment. So, in that connection, we'll discuss the introduction and the meaning and the very definition of probation. So, according to H.S. Cunning, probation is a matter of discipline and treatment. It is a conditional release of an offender under supervision as corrective measures, and the very object of criminal law is more inclined towards the reformation of the offender than to punish him. Instead of keeping an accused with hardened criminals in prison, the court can order personal freedom on the promise of good behavior and can also order a period of supervision over an offender. This is the concept behind probation. Black's Law Dictionary defines probation as allowing a person convicted of some minor offense, particularly juvenile offenders, to go at large under a suspension of sentence during good behavior and generally under the supervision or guardianship of a probation officer. Thus, instead of keeping the accused with hardened criminals in jail, the court may order personal freedom on the basis of good behavior. The court can also grant a supervision period for the accused. The main aim behind the Probation of Offenders Act of 1958 is to give an opportunity to offenders to reform themselves rather than turning into hardened criminals. So, Section 562 of the Criminal Procedure 1898 as amended, it stands as Section 360 of the Code of Criminal Procedure 1973 provides that any person not below 21 years of age who may have not been convicted for an offense for imprisonment up to 7 years are not convicted to death or imprisonment of life can be released on the basis of provision for good conduct. And now we'll discuss the very meaning of probation. The term probation is derived from the Latin word probate or provo, which means to test or to prove or I prove. When a person convicted of an offense as a special case by virtue of age or other reason is not sent to prison but is kept under supervision or observation for the purpose of correcting him as a good citizen, he is said to have been kept on probation. The official who supervises is called the probation officer. The probation officer is appointed by the state government or recognized by the state government if the society prefers any social worker. The probation officer is under the control of a district magistrate. The period of supervision is called the probation period. For example, when a child or a young person is convicted for the commission of a crime, he is not sent to prison in the execution of the sentence, but is kept under probation, under the supervision of a probation officer. Therefore, probation means the conditional suspension of a sentence by the court in selected cases, especially of young offenders who are not sent to prisons but are released on probation on agreeing to abide by certain conditions. Earlier probation was designed only for child offenders or juvenile delinquents. Now it can be extended to a delinquent of any age, generally up to 21 years of age. And now we'll discuss about the very definition of probation. Probation may be defined as a method of dealing with specially selected offenders and consists of conditional suspension of punishment while the offender is placed under personal supervision and is given individualized treatment. Professor Morrison and the chairman of Morrison Committee defined probation as the submission of an offender while at liberty to a specified period of supervision by a social case worker who is an officer of the court. And now we'll discuss the very objects. So the object is a permanently reform of the lawbreakers. So the main object of probation is to save some selected types of offenders from the rigorous punishment. Further, probation reduces crime rate and avoids overcrowding in jails. The aim is to reformation of delinquents as responsible citizens in society, to reclaim that young and fast offender to orderly society who has for certain reason fallen into bad company, have gone astray and landed into criminality. It is not meant for hardened and habitual offenders who are beyond redemptions. The main aim and objective of probation is to permanently reform the lawbreakers. It involves molding the habits into constructive ways by rehabilitation and reformation. The objective is to give a chance to the antisocial persons to willingly cooperate with society. This will also give him social protection and security. It is a substitution for imprisonment. Imprisonment will not always serve the purpose of eliminating crime from society. The object of probation law is more to reform the offender than to punish him. This is what we generally call probation. Simply, it can be understood as the conditional release of an offender on the promise of good behavior. So, in regards to that, we would like to discuss an important leading case decided by the Supreme Court, Jugal Kishore Prasad versus State of Bihar, where the Supreme Court stated that the aim of the law is to deter juvenile offenders from turning into criminals as a result of their interaction with seasoned, mature age criminals in case the juvenile offenders are sentenced to jail. It is observed that the Act is in accordance with the present trend of penology, which says that effects should be made with according to change and remote the offender and not to retribute justice. Modern criminal jurisprudence recognizes that no one is born a criminal. A good number of crimes are a result of a socio-economic environment. So now we'll go to the very origin and development of probation of offenders. So in that context, first we will discuss how it originated in United States of America. So in America, the idea of probation was coined for the very first time by Peter Oxzenbridge Thatcher Jr. in 1830. Then John Augustus in 1849. A Boston shoemaker is considered to be the pioneer of probation. He succeeded in releasing a drunkard to be convicted on probation from a police court. Later, he succeeded in releasing on probation 253 males, 149 females, and 2,000 boys. In 1878, probation laws were passed and probation officers were appointed in the United States of America. By 1921, 35 states of the American Federation passed laws for adult probation, and 47 states passed laws for juveniles probation. By 1956, almost all states in the United States of America passed probation laws. And now we'll discuss the origin and development of probation in United Kingdom or in England. In England, the institution of probation was accorded statutory recognition in 1907 with passing of the Probation of Offenders Act in 1907. Though it originated in 1820, the Probation of Offenders Act 1907 was amended in 1914 by the Criminal Justice Amendment Act of 1914, which was again amended in 1925. The Criminal Justice Act of 1948 repealed all the enactments in England and Wales. In course of time, the Criminal Justice Act of 1982 came into force to regulate the institution of the probation system in England. So now we'll discuss the origin and development of probation laws in India. So in India, the Reformative School Act of 1897, which dealt with the concept of probation, was passed in 1897. The institution of probation was accorded statutory recognition with the passing of the Code of Criminal Procedure in 1898. Section 562 of the code contains as many as 155 offences which come within the purview of probation. Later Children Act, which was passed in 1908, made provisions for probation. Section 562 of Cr.PC 1898 was repealed with the passing of the Probation of Offenders Act 1958. So, the Code of Criminal Procedure 1898 was amended from time to time and passed into law as the Code of Criminal Procedure 1973 and came into force from 1974. The code also made a provision for the system of probation under Section 360 of the Cr.PC 1973. Now we would like to discuss certain advantages of probation. Probation enables a convicted person to correct himself as a responsible citizen in society. And the second advantage is that the process of probation is less expensive when compared to institutional treatment, and that is imprisonment. And the third advantage that would be derived, the probation officer will be able to make use of all community facilities for rehabilitation. So now we'll discuss certain disadvantages of probation. Despite the above advantages or merits, the institution of probation is not free from certain disadvantages or demerits, such as the probation officer may be influenced as due to undue influence or political influence to furnish a good report so that the person convicted is released. And the second demerits or disadvantage is that it eliminates fear among children or young delinquents and accelerates crime rates. So now we'll discuss certain important landmark judgments or leading cases. So the first one is Basikesar versus State of Odisha in 1967, decided by the Odisha High Court. The fact in this particular case, and in this case 20-year-old was found guilty of an offence under Section 380, which deals with theft in dwelling house, etc. It was held that the youth had committed the offence not deliberately, and so the case must be applied as per the provisions of Section 3 of the Probation of Offender Act and can be released after admonition. And now we'll discuss another important leading case, and that is Ahmad versus State of Rajasthan, also decided in 1967 by the Rajasthan High Court. In this case, the court said that the benefit of the Probation of Offenders Act does not extend to anyone who has indulged in any activity that resulted in an explosive situation leading to communal tension. So now discuss another important leading case, Srimati Devki versus State of Haryana in 1979, decided by the Supreme Court. In this case, it was observed that Section 4 of the Probation of Offender Act Offenders Act 1958 would not be extended to the culprit who was found guilty of adopting a teenage girl and forcing her to sexual submission with a commercial motive. And now we'll discuss another important leading case of State of Haryana, that is Phul Singh versus State of Haryana in 1980. Supreme Court in this case held that the provisions of Section 4 of the Probation of Offenders Act 1958 should not be mistaken and applied easily in undeserving cases where a person in their early 20s commits rape. The court thus refused the application of probation on such a heinous nature of crime and convicted the person. So now we'll discuss another important leading case, that is Daulat Ram versus also of State of Haryana in 1972. In this case, Supreme Court held that the aim of this section was to protect the youth. The juvenile offenders would not be sent to jail if their crime was not as serious as to punish them with life imprisonment or death. Therefore, the provision should be liberally construed, keeping in view of the spirit of the embodied sections therein. And now we'll discuss some other important leading cases as relating to one is State of Tihar jail and of CBI and versus Sanjeev Bhala in 2014, also decided by the Supreme Court, making grievances about their release on probation of good conduct under the Probation of Offenders Act 1958, despite their alleged conviction under the Act, cannot be released on probation of good conduct under the provisions of the Probation of Offenders Act 1958, that a person convicted under the criminal laws as it was decided by the Supreme Court in this important leading case, and that is relating to State Tihar Jail, Central Bureau of Investigation or CBI versus Sanjeev Bhala in 2014. And now we'll discuss another important ruling of Madras High Court, and the leading case is P. Subramaniam versus Joint Register of Cooperative Society. The case was decided in 2000, where after releasing the appellant therein provision of good conduct under Section 4 of the Probation of Offenders Act 1958, their lordship have object thus been released on probation. This may not affect his service career in view of Section 12 of the Probation of Offenders Act 1958. And now we'll discuss another important leading case, that is relating to State of Uttar Pradesh, Kapil Dev Pandey versus State of Uttar Pradesh in 2023. The Allahabad High Court expressed that under the provisions of the Probation of Offenders Act 1958, a youthful offender under the Children Act 1960 or any other So, in Uttar Pradesh, the first offenders of the Probation Act of 1958, thus the provisions of UP Probation of First Offenders Act shall be followed. And now we'll discuss another important leading case, and that is State Srimati Indira S. versus State of Karnataka, decided in 2018 by the Karnataka High Court, where it was expressed that the choice of the offender for the purpose of sentencing has extended to the under the Probation of Offenders Act, and as long as appellant should be released on provision of good conduct. So, under Section 4 of the Probation of Offenders Act is directed as by the trial court. So, these are the important leading cases relating to probation of offenders. So, now we'll go to the very conclusion, that is relating to probation of offenders, and the very act is enacted aiming at reforming the criminals and the offenders. So, it is one of the most important subject of criminal jurisprudence, and in particularly reformative theory of punishment. So, to conclude, it can be said that the measure of alternative punishment, probation, and the objective of the theory of reformative punishment would be achieved only if the judiciary and the administration work together. It would be of great benefit to a country like India, where the jails are often overcrowded with frequent human rights violations which would harden the human inside a prison. Probation is an affirmation of the human inside every being, and it must be given importance. The reform and rehabilitation process have to be worked out in the context of existing social conditions to achieve the ultimate objective of reclaiming those offenders to orderly society.